Do you think that law clerks over the last 50 years have contributed to the length of opinions?
Yeah, absolutely. Absolutely. And I was a law clerk. I remember what I knew and what I didn't know when I started. When you start as a law clerk right out of law school, everything is new to you. And so there's a tendency to go back to the very beginning and recount a lot of stuff that experienced lawyers and judges understand. The law clerks are not in a good position to do the sort of deletion of unnecessary details that I was talking about before. So they do tend to put everything in, and I think they feel that if they produce a lengthier product, it's more impressive, that a certain length and heft to the opinion is necessary to make it authoritative.
What would happen if a justice took a finished opinion and said to a clerk, I now want you to cut this in half and summarize? Do you think much would be lost?
It would be good. It would be good. But the clerk might not really know what to take out. So probably what you would have to do is sort of what I was talking about with my father going over my old school essays, to give the clerk an idea. Well, let's sit down and let's go through this line by line and sentence by sentence and see all the things that we can leave out, all the things that we can simplify. And I wish we had time to do that. We generally don't have the time to do that.
You often use footnotes in your opinions. What is the best use of footnotes in a judicial opinion?
I use them. I try not to use them excessively. Maybe I haven't always followed that over the years. I don't think substantive points generally shouldn't be in a footnote unless it's a point that's not directly, doesn't fit in directly with the argument that you're making, but it's something that you want to note that you're not deciding something. That would be something you put in a footnote. Maybe you're going to quote a statute or a regulation, put that in a footnote. I don't like to take a significant discussion of a point that in the case and put it in a footnote.
If Caroline products could be rewritten, that footnote would be moved up, wouldn't it? Don't you suppose?
Probably, yeah.
Can bad writing lose a strong case?
It can. It can. It can, because you may totally fail to convey the point that you want to make to a court. If you wrote more clearly, the court just might miss your point. There have been times when I've read a brief and I just didn't see what they were saying, or I thought the lawyer was saying one thing. And then later, sometimes when the lawyer argued the case orally, the lawyer would be more articulate in the oral argument than the lawyer had been in the brief, and I would say, oh, that's what you were trying to say. Now, if we hadn't had the argument, or if the lawyer hadn't been more articulate in oral argument, the whole point would have been missed.
Can good writing win a marginal case?
It can, certainly. Yeah. And the marginal case, by definition, is one where you're pretty close, and good writing may persuade the judge that an argument should be accepted. Certainly.
In your opinions, you always seem to have a summary paragraph up front giving the essence of the opinion right there. Why is that important to you?
I think it makes the opinion easier to read. It makes it clearer. You tell people where you're going, they can follow along with the steps in the argument. I know some of my colleagues didn't used to like to do that because they thought people would stop reading after the introductory paragraph. But I think a summary is very useful. An old colleague of mine in the SG's office once said that he spent hours and hours and hours on the summary of the argument in the brief because he thought that was critically important. That would be the first thing he thought that justices would read, and he wanted to start out with, that. I think that's very important in a brief. I would, and a lot of lawyers, particularly in the Court of Appeals, just sort of blow that off. They've written the whole brief, and now they have to do the summary. It's a requirement of the rules, so they don't devote any attention to it. Sometimes it's a few sentences. I think that's really a missed opportunity.
You think it's the most important part of a brief?
I do, in a way. I do. I think it should be self-contained. I think that somebody reading the summary of the argument should understand what the case is about and the essence of the argument that is being made, and should be persuaded to agree with that argument by what's in the summary, and then in the rest of the brief you develop the points.
Would you be as surprised as I was, or you don't know how surprised I was, but I was surprised in interviewing Justice Scalia to learn that he thought the summary of the argument was entirely dispensable.
Well, I disagree with him on that. I think it's very helpful. It's the first thing I read.
You use a lot of paragraph transitions in your writing, such as beginning sentences with "but," which I have long endorsed and encouraged people to do, to signal a rebuttal, and starting paragraphs with first, second, finally as guideposts. How important are these transitional devices to readers?
I think they're important. I think it's easier for a reader to understand what you're saying if the reader is not on sort of a mystery trip. So if you start out by saying where you're going to go at the end, and then you make it clear as you go along just how you're progressing through the argument, the reader can understand more easily what you're trying to say and how you're getting there and how the points relate to each other.
Do you agree with me that a lot of brief writers seem to have trouble with these transitions? Sometimes you get to a new paragraph.
They do, absolutely. You know, the old rules about writing are sound rules. Start off the paragraph with the topic sentence most of the time, and there's a reason for those, I know.
Are you conscious in your own writing of trying to keep the narrative flowing? I
am, yes. Because I think I think it makes it easier to read. I also think that it makes for a more logical argument. It's a kind of a discipline if you understand exactly how all the pieces of the argument you're making fit together. It makes for a more logical argument and a more persuasive argument.
If we exclude present justices on the court, what justices' writing do you most admire?
Well, maybe the justice who's seated behind you, Justice Jackson. I thought he wrote extremely well. And Justice Holmes wrote very well. He used language very well. He was so brief, however, at times, and so concise, so pithy, that he probably went further in doing that than I think anybody would want to do in the modern era, where I think we've come to expect more argumentation in our opinions than was customary in his opinions. But he certainly was a good writer in the broad sense of the word, used the English language beautifully.
Do you ever look at the old Supreme Court opinions and just find it very difficult to figure out what they were driving at?
Yes, absolutely. If you go back to a certain era, if you go back to the late 19th century, sometimes earlier than that, the writing style was so ornate. It is sometimes very hard to follow what's going on.
The first Justice White was almost impenetrable,
yes,
wasn't he?
Yeah.
But if you go back far enough to Chief Justice Marshall, do you admire those early 19th century opinions?
I do. I think that the writing of the colonial era and the period right after that was better. I think that was a time when the leaders in the bench and the bar were probably as a whole better educated, more formally educated than some of the justices later on. It may also have just been a change in style.
Granted that we work in a system based on precedent, is there any good reason that we have to continue interlarding paragraphs with a lot of volume numbers and page numbers?
Yes and no. Probably we go overboard. Probably some of it is attributable to law clerks because that's how they were taught to write in law school and on law reviews. And there's I think a reason for insisting on that in student writing. I think it is a good discipline for them to a degree in student writing. So I think we certainly could get rid of a lot of it, but there are reasons why judges put in lots of citations. It's felt to strengthen the argument, make it appear that the argument is less just something that the justice or the judge invented and simply a continuation, a reiteration of things that have been held and said before. So yeah, you're running into the wind and trying to get rid of that.
But it is a curious thing that those law review editors who are now clerks did not have all those numbers up in the middle of the discussion in law review.
Oh, you mean putting it in the
footnotes.
text as opposed to the footnotes?
Yeah. And then they get into working on opinions or working on briefs, and suddenly it just blows the paragraphs. It's amazing.
It could be, the citation certainly could be dropped to footnotes. But I made a decision when I became a judge that I would not write opinions in a form that made them seem like law review articles. I wanted to, and it was just sort of a quirk, but I wanted them to look like older judicial opinions and not like a law review article that had been printed in the official reporter. So I almost never use topic headings in the opinion. Maybe that some judges will say facts, procedural history, discussion, and maybe that makes it clearer where you are in the opinion, but I sort of for a quirky reason I left that out, and so maybe that's the reason why I wouldn't put the footnotes in, put the citations in footnotes.
Let me ask you a question about legalese, and by that I mean legal jargon, not terms of art, not habeas corpus, but the instant case and pursuant to and so on. Do you have an opinion on legalese?
Well, phrases like that are totally unnecessary, and they can be eliminated. What makes legal writing, I think, more difficult than other types of writing is that very often you have to use a particular form of words because it's the legal term, because it's the language of the statute, because it's what was said in an opinion. And so in order to be precise, in order to avoid any impression that you're changing the law in any way, you are stuck with reiterating these same phrases, which may be very cumbersome phrases. You can't try to develop a synonym or some alternative language. If you do that, it's going to introduce ambiguity into the opinion. And that makes it harder because in ordinary writing, of course, you wouldn't do that. You would try to boil down those complex phrases or find variants of various ways of saying the same thing. You're limited in your ability to do that when you're writing an opinion or a brief.
Somebody just entering the profession wants to be a really good writer. What would your advice be?
I think you just have to go back to the rules of writing that you would use in another context and try to apply them in legal writing as far as you can without sacrificing, without unnecessarily, unjustifiably sacrificing the precision that you need in doing technical writing.
Thank you very much for your time today.
You're welcome.